A bid to amend election laws to introduce new rules on election appeals continues to generate heat, with governors saying they will go to court to challenge them if Parliament passes them. The Miscellaneous Election Amendment Bill of 2017, now in the second reading, proposes changes to the election law to allow for only one appeal in an election petition. This means the Supreme Court will only hear presidential petitions. Those involving governors and members of parliament will end at the Court of Appeal, while those involving MCAs end at the High Court. Governors now say the bill is unconstitutional.
This is a contravention of Article 48 on access to justice and Article 50 on fair hearing. And it is not in the best public interest to limit the rights of citizens who feel aggrieved by an election to get a second opinion and a third opinion to the highest court in the land.
The bill was introduced by the Justice and Legal Affairs Committee, though it's claimed to be a brainchild of the judiciary. Chief Justice David Maraga put together these draft proposals and forwarded them to Parliament in what he says will ensure that election disputes are settled in time. Lawyer and member of the Judicial Service Commission Tom Ojienda also questioned the constitutionality of the bill in a petition to the Speakers of the National Assembly and the Senate. He says the bill threatened the country's fledgling democracy, fundamental freedoms in the Bill of Rights, and the country's political stability. Amid claims, the bench put together the proposed amendments without involving the JSC.
I want to inform him that it is not possible to amend the Constitution through an ordinary legislation. If I were to refer you to my own petition, which was the first one to break this ground, we went all the way to the Supreme Court. And the Supreme Court was able to pronounce it itself on the constitutionality of appeals from the Court of Appeal on petitions.
In 2013, a total of 188 poll-related cases were filed in court for determination, including the presidential petition. Out of this, 24 were allowed and 115 dismissed on the weight of arguments before the court, 17 were withdrawn, and 31 struck out on technical grounds.
This is why we established the Supreme Court. We didn't establish the Supreme Court for them to just lie high and up there without any cases.
The bill now awaits the Speaker's ruling on whether it will proceed following the challenges on its constitutionality. Sheila Sendeo, NTV.